I look forward to just being a better person and just improving my lifestyle and doing better. But I've never done that before, Your Honor.
But explain to me, why was that the day?
I was just trying to get home.
What were you thinking? I mean, 110?
I honestly, Your Honor, I don't.
In today's video, we have 4 hearings from Judge Washington's criminal docket. Each hearing gets better and better as they go, so watch to the end for the best. Let's get into the video.
State of Michigan versus Ryan Webb, case number 20S00255.
Rachel McDuffie for the people.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Webb. And sir, can you unmute and state your name for the record, please?
Ryan Webb.
Thank you. Good morning, sir.
Good morning, Your Honor.
And Your Honor, at this time, we have not received any information about an offer. In this case, we would like to try to get it resolved. However, if we could have a brief adjournment and then address bond, please.
All right, because he was arraigned on a bond violation on April the 4th, 2023 before the magistrate.
I'm not sure that I've received, I have a bond violation from 2021. Is that the same document?
Trying to figure that out myself.
Okay.
Yeah, it looks like he's been gone since 2021.
Okay. And he did represent to me that he was in treatment for some time in Kentucky. After that, he had forgot to update his address with the court, and he didn't receive any sort of notice going forward until he was picked up on this warrant.
Well, the bond violation indicates that he stopped testing. He last tested positive for cocaine on July 30th of 2021, and buprenorphine and THC. And he had tested for those twice already, July 26th and July 30th of 2021. And then he simply stopped testing from August 3rd and apparently until we saw him again in 2023. This is operating while intoxicated case.
Understood. And sir, you do admit that you had stopped testing, correct?
Yes, I do. Yes, ma'am. Correct.
Right. Before I accept the plea, sir, I have to advise you. I mean, I know the magistrate did, but I want to make a record here that you have a right to have a hearing on this matter. And if you are found guilty or if you admit guilt, then your bond can remain revoked, or at this point, it looks like it's at 5,010%. Do you understand that, sir?
Yes, Your Honor. Yes, I do.
Understanding that you want to waive your right to have a hearing and admit to the bond violation?
Yes, ma'am. Yes, Your Honor.
Raise your right hand. Do you swear affirm the testimony about the trial will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor, I do.
Thank you.
Thank you.
First of all, you acknowledge, sir, that you were under court order to have no illegal drugs or illegal substances in your body?
Yes, Your Honor, I do.
And you acknowledge that you tested positive on July 26th and July 30th of 2021?
Yes, I do.
And then in addition to that, sir, you also missed August 3rd, August 13th, August 25th, and every day after that until now for testing. Is that correct?
Yes, Your Honor.
All right, thank you. I find that there's a valid basis for the bond violation, and it has been willingly and knowingly made. Are you satisfied, Ms. McDuffie?
Yes, Your Honor.
All right, Ms. Cleveland?
Satisfied as well. Thank you.
All right. Now, Ms. Cleveland, you said you wanted to adjourn this so you can have time to talk to Ms. McDuffie about an agreement, a potential resolution,
Yes, please.
and you want to address bond.
Yes, and in terms of bond, we are asking if he could be released with a GPS tether and a personal bond. He's been unable to post the bond so far. He did express to me that he has been working on his sobriety. He is now in a weekly Suboxone program. He does live with someone that he met in the program who is assisting him in staying sober, and he does have a reliable address that he could be tethered to.
Well, all right, Ms. McDuffie.
I'm just curious. I'm a little bit confused about how he ended up in Kentucky, but so he's in a Suboxone program here locally. It sounds like.
Yes.
Okay. So no objection to the release with the GPS tether. His testing requirements, I guess, I'd like to know what those are, or if there's a new order that needs to be entered.
He would need a new order to be entered. He was supposed to drug test within 24 hours. It looks like he's set up for intermediate testing right now, which means that he tests 3 to 4 times per month.
Okay. No objection. I'm just looking. It looks like the majority of the failures to appear are apparently at some point he's in. Okay, let me just ask this, Your Honor, because there's another note in GIS from back in 21 that says he's in Texas. Are we under a no leaving the state without permission situation here? Because
Yes, we are.
that's my concern, is that he's apparently been in 2 different states so far.
No,
And
it was just Kentucky. I never went to Texas.
okay, so at least 1 state so far. So my concern is just that. I understand that his reason for doing that was to seek treatment. We don't have any information about what happened there, but I'm just concerned about him leaving again.
I think the court, hang on, sir. I think the court did know that he was in Kentucky though, because we had actually received that information from Heather Ball. So I think he had updated the court on that. Whether or not there was permission to leave, I'm not clear. I wasn't on the case at that time. But I do think that the court did know at the time.
Well, the court may have known, but it said right in my order, no leaving the state without permission of the court.
Understood.
All right. And as far as the Suboxone is concerned, he was supposed to be on that. He was prescribed that back on July 22nd of 2021. My notes talk about it right here. And he was not supposed to be released from the jail without proof of Suboxone prior to release. So that is not a new thing for him to be on Suboxone. And that we have no proof that he was in treatment in whatever state he was in. That is my other concern. However, there is no objection from the people for him to be released on a GPS tether. So I'm going to release him on a GPS tether. And testing. I'm going to actually make it 5 times per month. Okay. He was supposed to be in Isaiah House. Do we have any proof that he even completed that?
I do not have any documentation as of today. Sir, do you have documentation that you completed the program?
I didn't complete the program, Your Honor.
Okay, thank you. May 11th, 2023 at 9 a.m.
I appreciate your time.
Thank you.
Third, if you cut the tether off, you understand that that is a felony, right?
Yeah, no, I just want to do whatever I have to do to get this taken care of, Your
Just
Honor.
making sure you fully understand.
I'm not going to mess with it. I promise.
Okay. All right, we'll see you back here when? Mr. Webb, when we'll see you back here?
Oh, whenever I need to be here. I don't.
You don't even know what I just told you, did
You said the GPS tether, right?
That's all you heard. And you need to be here on May 11th
May 11th. Yes, ma'am.
at 9 a.m.
9 a.m. I will be here early. 8:30.
It's on Zoom.
Oh, it's on Zoom.
Yes.
Okay. I will be on it. No problem.
All right.
I appreciate your time.
You're all set, sir.
Thank you. Oh.
Mhm. State of Michigan versus Justin Becker, 22S00177.
Rachel McDuffie for the people.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Becker. And sir, can you unmute and state your name for the record, please?
State of Michigan versus Jeremiah Palmer, case number 22S00439, as well as 22S00467.
Rachel McDuffie from the people.
Again, may it please this honorable court, Gerard Scanlon, P number 74992, bring on behalf of Mr. Palmer.
Thank you. Mr. Palmer, please state your name again.
Jeremiah Palmer.
Thank you. What would you like to do on behalf of your client today, Mr. Scanlon?
Your Honor, after having a thorough discussion with my client as to his options, my client wishes to enter a guilty plea. He would like to provide an explanation as to why it is he did not obtain the scram tether as ordered by the court.
All right, sir, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. You may lower your hand. Sir, as to this particular case, violation, do you acknowledge that you failed to comply with this court's order to go and get the scram tether placed?
Yes.
All right. Are you satisfied with the plea of guilty to the violation? Ms.
Yes,
Mc-
I will.
Provide my explanation. I mean, I've been working 12 hours. I walk home about an hour walk each way. That's 14 hours of my day. And
Mr. Palmer, I got it. Thank you.
All right, I'm sorry, Ms. McDuffie, I'm not certain that the recorder picked up your response.
Yes.
Thank you. And I believe that you said you were satisfied, Mr. Scanlon.
Satisfied, Your Honor.
Thank you. All right, you may proceed, Mr. Scanlon.
Your Honor, Mr. Palmer is an individual that has battled a severe addiction to alcohol. And I'd like to report to court that in battling the severe addiction that he has to alcohol and his dependency upon alcohol, he's making tremendous strides. He works for Contractor Steel, where he's been employed twice. He's working 60 to 70 hours a week. He understands the gravity of the situation that he finds himself in. He has no transportation. And despite the fact that he has no transportation, he is in fact going to work. He was attending meetings, group meetings. He was attending AA. He was on the breathalyzer program where he was supposed to be blowing into the breathalyzer and testing there. And as far as I knew, up to a certain point, there was no violations of that breathalyzer. As far as I know, he's steadily paying on his fines and costs. There's been no indication from probation that he's behind on his fines and costs. He's making payments towards that. He has to do his 1 day of community service. Probation and the goal of probation is to rehabilitate the individual. They want to make the individual a productive member of society. They want the member to know that you did something wrong, but the court has compassion and understanding and realizes that you did something wrong, but we're going to give you an opportunity to make it right. And that is the goal of probation. It's to rehabilitate the individual back into society. And I believe in this particular instance, it's working. This individual has not drank a drop of alcohol in quite some time. He realizes that he made some very grievous mistakes in his life, and he wants to move past these grievous mistakes that he has made. And I believe that he is, in fact, making strides towards that goal.
Mr. Scanlon, I didn't want to interrupt you, but the reason why he was supposed to go get on the scram tether was because he failed to comply with the sober link. He failed the test.
And I indicated to the court the last time, I believe, that yes, we were aware that he had failed that sober link test, but I believe that he had tested shortly thereafter. And I think Mr. Palmer can attest to this. He had tested shortly thereafter and it was negative. I believe he had gone to the police station or something like that.
no, I had missed my test by like maybe an hour or two, and then I would take it because I'd be out on the floor working.
And so he would take the test, Your Honor, and it would be negative.
I have already made my ruling about how I felt about that, which was for him to get the scram tether, and he didn't do it. Ms. McDuffie?
Your Honor, with that being said, it's difficult to sort of view this as an entirely sort of, I agree, the purpose of probation is absolutely to do those things and to rehabilitate, but we're in a situation now where we have the mistake of the original offense says, and the mistakes made on probation. So obviously, I agree that he does need a scram tether, and that will help to prevent any issues with timing in his work schedule as well. But I'm going to leave the rest in the court's discretion with how to move forward. It's difficult for me to look at this as everything is okay, because it clearly isn't, and he had to be brought into custody to get arraigned on a bench warrant just a few days ago.
Mr. Heaton, are you able to tell me whether he was still blowing in SoberLink from February the 14th until he was brought into custody on April 10th?
I can look it up right now, Your Honor. I did want to add that there were, while I'm looking it up, there were 42 missed SoberLink tests. There were several that were never retaken, and there were several days where there was no SoberLink test at all. So just wanted to add that to the record.
I appreciate that, Mr. Heaton.
Can I say something, Your Honor?
Just one moment. Is he on scram tether now?
Yes, he is, Your Honor.
Sir, were you still blowing in your SoberLink
Yes, I
from
was.
February 14th until April 10th?
Up until it stopped working on me, which was like 2 weeks ago.
What would you like to say?
I know I missed, but I had left it at work the one time from Friday or Saturday morning until Sunday night. So that was like 3 tests right there that I missed. I had no way to get it because nobody's in the shop from Saturday at like 9 a.m. till Sunday night at 9.
You told me that before.
So I was just clarifying.
And as such, I ordered you to do scrub and you just didn't go.
Your Honor.
Yes, Mr. Heaton.
So I don't have a report of there being any tests. All I have is the report stating that the SoberLink device was deactivated after the warrant was issued and several notifications were sent to the device, reminding Mr. Palmer to come in for the scram tether.
All right, thank you so much. Can I see counsel in the breakout room along with probation? All right, we're back on the record in the Jeremiah Palmer matter. Mr. Palmer,
Yes.
this is what I'm gonna do. I'm gonna extend your probation for an additional 6 months.
Okay.
Is there anything else anyone else wanted to say prior to me sentencing Mr. Palmer?
No, ma'am.
Just thank you, Your Honor,
Thank you.
on behalf of my client.
I do appreciate it.
And I'm gonna tell you this, Mr. Palmer. If you miss one of your downloads at any point in time, I'm giving you the entire sentence.
Okay.
Okay. I want to do a review in this case in 90 days on July 13th, 2023 at 10 a.m.
Thank you, Your Honor.
Okay, sir.
Thank you, Your Honor.
Thank you. All right.
All right, have a day.
State of Michigan versus Leticia Kirk, case number 23-00045.
Rachel McDuffie for the people.
Good morning, Your Honor. For the record, my name is Jeffrey Bennett. I'm appearing with and on behalf of Ms. Kirk today. Ms. Kirk, could you unmute your phone and state your name for the record, please?
Leticia Kirk.
Good morning, Ms. Kirk.
Good morning, Your Honor.
We're here for sentencing today.
Yes, Your Honor. And I would indicate that Ms. Kirk and I have discussed the probation report and recommendation. We don't have any changes to it. What I would actually, I don't have any changes to the report, and we're going to ask that you follow the recommendation of fines, cost, community service, and breaking the cycle class. I do have some additional allocution when that time is appropriate.
Thank you, Ms. McDuffie.
I just have a question. I guess I'm a little bit confused about. Okay, never mind, Your Honor. I think I was just a little bit confused about the 90-day review and the 15 days community service. So we're so the entire term of probation is what?
There's no probation term.
There's none. So this is
a sentence to a recommendation for community service, fines and costs, and complete some programming. And if she doesn't do that, then she goes on probation.
okay. So she has the 60-day time limit to do that, and then a review in 90 to see that. Okay, I got it. Okay. It's a very, very generous recommendation. I'll just say that. So nothing further from the people.
Thank you.
Your Honor, just to add a little bit more than what's contained in here, Ms. Kirk is a veteran of the Armed Services. She works at the Department of Veterinary Affairs currently. She has been in weekly treatment through the VA since January of 2023. She attends outpatient therapy every Thursday. And for those reasons, and including the other rationale contained in the recommendation, we believe that the sentence, which does not currently include probation, is appropriate in this case.
Thank you. Ms. Kirk, is there something you'd like to say? I specifically like to hear about why you're driving so fast on the road while you're driving, while you're using alcohol.
Your Honor, to be honest with you, I just want to say that there is no, I take full responsibility for my actions and my behavior, and that I know what I did was not right. In my speeding and drinking and driving is something that's not indicative of my character. I've never done that before in my life. And I look forward to just being a better person and just improving my lifestyle and doing better. But I've never done that before, Your Honor.
But explain to me, why was that the day?
I I was just trying to get home.
What were you thinking? I mean, 110?
I honestly, Your Honor, I don't
Do you
I don't
do it?
I don't think I was going that fast, Your Honor, to be honest with you. But I know I was speeding, Your Honor. I can attest to that, Your Honor. And I was just trying to get home. I was almost home.
Ms. Kirk, I have some serious reservations about following the recommendation in this case. Trying to find her on my screen and I don't see you. Can you speak again for me so I can see you? There you are. I see you. You moved to the middle. And the reason being is because, I really need some explanation as to why, you say you've never done it before, but to be going at least 100 miles per hour and up to 110 with an officer trailing behind you is extremely, extremely dangerous.
Yes, Your Honor, it truly is. And I know I put myself in danger and I probably put other people in danger with my behavior. But I do not do that, Your Honor. I do not get in trouble like this, Your Honor.
Your Honor, could we approach this just really quick?
Yes. Yes.
What's going on?
All right, we're back on the record in the Leticia Kirk matter. Ms. Kirk, it is the sentence of this court that you serve 15 days of community service, fines and court costs in this case for a total of $1,295. You must complete the first step referral program, Breaking the Cycle. You also must attend the VA outpatient therapy and provide proof that you're attending that within 14 days of today's sentence. We'll do a review on this case on July 13th, 2023 at 10 a.m. Do you have any questions about your sentence, ma'am? You're muted. Did she just leave? No, she turned off her camera. Now your camera's off and you're muted, ma'am.
I don't have any questions, Your Honor.
Thank you. I'll see you back here on July 13th at 10 a.m. now.
Thank you.
You're welcome.
Okay. State of Michigan versus Martinez Ferris, case number 16 FB 1790.
Rachel McDuffie for the people.
Is Martinez Ferris present?
I'm here, Your Honor.
Good morning, Ms. Ferris.
Good morning.
You filed this motion to set aside the conviction on your own?
Did.
And Your Honor, last time we were here, I don't have the AG's opposition letter, but I had identified two major issues myself that was probably going to prevent this from going through. And Ms. Ferris, pardon me, was advised to get an attorney, and that's why we adjourned to today, to sort of guide her through what those issues are and the status of this. I don't know if she was able to get someone to assist her.
The attorney listed on my docket actually denied representing my case. He believed that there was a slim chance of a positive outcome on the matter. And I've also been told that my mental health would not be taken into consideration with this court or with this case by him. So I'm looking for another counsel. I'm asking for more time to find another counsel on this matter with someone who does kind of maybe believe in me a little more. If not, I would ask for the right to represent myself or to express my right in representing myself if I can.
All right, the problem, ma'am, is that there are rules about when you can get a conviction set aside. And it's essentially telling you that based on what we have here, you don't, this is not eligible for setting aside, but I will give you time to speak with another attorney so maybe you can understand what's going on here. I will adjourn this out one more time for you to do that. The next time you come back, I'll be making my ruling on this.
You can make your ruling today, actually, and I can just represent myself if you're telling me it's going to be a waste of time.
Well, I think you should talk to an attorney.
I'm sorry.
Go ahead.
I was going to ask if I could just make a record of the issues that the people identified, so that perhaps when Ms. Ferris does go to find an attorney, she'll be advised of what some of those issues are.
Okay. You may just...
One of the issues that the people identified was that it's just simply too early. Based on the timeline and the required 5 years after the end of the sentence, she would not be eligible, as far as I can see, until May 3rd of 2024. In addition to that timeline being too early, there's also a conviction, which I think that she already acknowledges, from just last June. So that's going to add an additional waiting period of a few years based on a recent conviction.
Okay.
So those are the two big things that I found in terms of the timeline for when this would have to happen.
Judge, you can make your ruling today, actually. That's fine. I don't want to see counsel anymore.
All right.
I had one more thing to say, but
I want to just withdraw it so that there's no denial of it. Would you like to just withdraw it today and refile it when you become eligible? Because when you file and it gets denied, it makes it more challenging in the future to get it when you do become eligible.
Sure.
All right. I will note that it is withdrawn at this time so that you don't get a negative ruling. Okay?
Sure.
All right.
Thank you, Your Honor. I was still going when Ms. Ferris started talking, but the last thing was just that there's also the matter of outstanding restitution. I'm not exactly sure how that affects eligibility as well, but that's another thing in terms of the end of her this current case, is that there's still that
$24,000 in restitution if I can't get a job, you guys. That doesn't make sense. Nobody is accepting me for employment to make money to pay restitution. So I'm supposed to wait another 5 or 6 years to get a job to pay you guys $24,000, which will stack with interest. It's no way out for me in this situation, honestly, if we all being honest here. I don't know what we're going to do about restitution. I can't find employment long enough or employment good enough for $24,000. on top of me serving 2 months in jail.
Like, yeah, you should probably take my advice and talk to an attorney at least about that part. Okay.
Sure.
The motion is withdrawn at this time. All right. Thank you, ma'am.
So I will not have to show up here anymore?
No, you don't have to show up for anymore.
Okay, have a good day.
Thank you. The Thomas Evans matters. Case numbers 22S00450 as well as 22S430.
Rachel McDuffie for the people.
Assistant Public Defender Melissa Kleeman on behalf of Mr. Evans. And sir, can you state your name, please?
Thomas Evans.
Good afternoon, Mr. Evans.
Good afternoon, Your Honor.
All right, we're here on a bond violation as well as a pretrial.
Yes, and I did have the chance to speak with him about the bond violation. He is denying it and asking to set for a hearing at this time.
All right, we'll give him his hearing. The hearing will be on April the 20th, 2023 at 11 a.m. Pretrial will be at the same time. I have a report here that indicates that the download shows that he blew 0.0243 on April the 12th. .017187 and 0.046, and there was a tamper that was confirmed. Ms. McDuffie.
Your Honor, we got this report following our last set of hearings where Mr. Evans had been ordered to get a scram tether upon the assumption that he was going to have to immediately report to Wayne County Jail on March, I think it was 29th of the sentencing. He ended up getting until the 14th to do so. We requested the downloads from that tether. So these are brand new violations just from the short window of time between our last hearing, or actually his sentencing in the Wayne County case, and his upcoming pretrials here. That's the previous reason that we were concerned, because I don't know why Wayne County doesn't have him apparently testing for alcohol, but the same thing has been a pattern of repeated positives on these tethers after he has sort of a disposition in his other case, as if he has nothing to lose and is going to go to jail anyway, which is our concern. That is obviously a continued concern. We have multiple consumption and tamper events on that tether just in early April, and it's still early April. So Mr. Evans has the right to challenge that result, as I think he was going to originally with the last couple of violations, but the people could not have any greater concern in this case. I did indicate, I think on the record last time, but just to be clear, there are no offers. There are no breaks to be given here. And with respect to the pretrial, I just wanted to make sure that that's clear. Mr. Evans would need to plead as charged on both cases.
All right. Anything from you, Ms. Kleeman?
I'm sorry, I didn't hear you, Your Honor.
Anything from you on this matter?
Not this time. I would just say Mr. Evans again adamantly denies this allegation of the bond violation. He is going to have to turn himself into the Wayne County Jail on this coming Monday for the case down there.
Bond is set at $50,000 cash assured. Go with the officer, sir.
That's on both cases, Your Honor.
Yes.
Thank you.